Hello, this is John Milburn for Central Queensland University, LAWS11057 Introduction to Law A. This is week 5, it's the 26th of November 2013, and the topic for this evening is communication, collaboration and self-management. And the topic is based around chapters 9 and 10 of the text, The New Lawyer by James and Field. I will be referring initially to the notes which have been prepared by my colleague and the usual lecturer, Wayne Jones, and the material is really all about communication in its various forms. Now, there'll be plenty of time for questioning, but what I might do is just make a start. If you could have a look at the notes, the lecture material that has been prepared, which is under week 5, and I'll work my way slowly through that, and then I'll work through the text. So everyone happy to proceed on that basis?
Yes.
Thank you. All right. Now, a couple of basic things in the definition, key terms. Affidavit is a sworn statement in terms of evidence, as opposed to a mere statement, which might be used as a preliminary document. So an affidavit is sworn. It has the same effect in reality as a witness attending in court and swearing on the Bible or affirming that on oath that what they have to say is correct. Can anyone think of the ramification of that, of an incorrect affidavit, perhaps lying in an affidavit?
Perjury? Yes,
exactly. And the same potential ramifications are there. So it could be subject to criminal prosecution. Thank you. The next thing I wanted to mention was the brief to counsel. Now, this is the formal name for the document that is prepared typically by a solicitor, presented to a barrister, and the brief to counsel, counsel being another term for barrister. Note the spelling is C-O-U-N-S-E-L as opposed to C-O-U-N-C-I-L, meaning the Brisbane City Council or the Rockhampton City Council. So the brief to counsel is a document providing the instructions, generally for the barrister to appear in the court proceedings, but it may be for the barrister to prepare documentation or attend a mediation session. Now, file notes are used by solicitors every day. It's very important to document the meeting, and that's recorded in a file note. The significance of that is that if the file note is prepared, as we say, contemporaneously, it will have a great deal of weight when it comes to court proceedings. In other words, if we have any form of conflict between the parties as to what was said during the meeting, the file note being prepared at the time is more than likely going to be accepted as being an accurate reflection or reference to what was said during the course of the interview. So it is very important that it's prepared and that it's prepared as comprehensively and in as timely a fashion as possible. One of the difficulties, of course, and you've seen a couple of times that I've gone to write something, is it's very difficult to be writing and engaging in conversation with someone. So one of the techniques that I use, again, coming back to voice recognition, is occasionally I'll conduct an interview and just briefly make recorded notes during the course of that interview so that I'm getting the best of both worlds, not breaking concentration too much with the client. So that's the file note. In terms of communication skills, we've talked about the need to communicate effectively in writing and also verbally. Now, when we talk in terms of effective communication in writing, that's not just the preparation of documents or the preparation of court material, such as a court application or affidavit material, but it's also the preparation of letters and file notes. So it's everything. you would have seen already that there's a strong emphasis now on preparing documents in a very simple form. We don't like to use what we call legalese. Has anyone heard of that term before, legalese? Legalese. Legalese is really just a description of archaic legal language, very convoluted and difficult to understand. Examples are using words like hereinafter, hereinbefore, all very silly words really. So from what we try to do now is prepare documents in a very simple manner, and I'm very keen on short sentences. I'm keen on getting to the issue very quickly. So any questions about what I've said so far? All right. In terms of oral presentation, it's not just a matter of presenting matters in court, but it's also a matter of communicating effectively in a number of different forums. Most lawyers are either in business or work for a business or for a government agency, and communication within the organisation is always very important, but also communication with colleagues and clients. And you'll see in the reading material the emphasis on trying to tailor your communications to the person with whom you're communicating. So the purpose of the communication and the target audience is also very important. Generally speaking, therefore, if you're drafting something which is to be interpreted by people who are not necessarily legally trained, then you should keep your language as simple as possible. And in the ordinary spell check, which is part of the word process, there's a little thing that I'll try to find now, at the risk of not being successful, which is a very useful way of just reviewing how well you've done in terms of clarity and readability. So if I can now share screen, I'll take you to my other desktop. With any luck, you'll see a Word document, and you can see a Word document now. It's the notes. Now, can you see my cursor? I've just gone to the top left. I'm under review, spelling and grammar, and if we run the spell check, which is now over here, I'll just ignore everything as quickly as I can, because what happens at the end of the spell check is should come up with a readability function. And those of you who don't use the spelling and grammar, it's probably a timely reminder to ensure that you do, and you really must use it on all occasions, not just for presentations in assignments, but just generally. Does anyone not use the spelling and grammar check? While we're waiting to click through this, does anyone have any other tips or suggestions on using word processing or Word? Perhaps ought to have selected a shorter document. All right, finally, I've got my way through to a thing called readability statistics, and you'll see, most importantly, passive sentences, 7%, which is very good. There are not too many passive sentences in that material. Most of it is written in the active sense, which is what we want. The flesh reading ease is quite good at 48, and the grade level is very good at 9.7. What we want to do is try and keep that number down as low as possible. So it's essentially saying that year 9 level is what we've written this at. And if you've got a readability quotient that comes in at 13 or 14 or 15, then it's really probably going to be too complex. So that's worth putting into your system, just to keep an idea of not only the number of words, but also the number of or percentage of passive sentences, and the grade level. Okay. Just reading further through the notes prepared by Wayne. When it comes to written communication, the other thing that you want to try and do is keep down the number of words generally and try and keep the sentences short. So you may be called upon in practice to redraft something which is really quite convoluted and unnecessarily long, and try to make it as short and sharp and as readable as possible. Notes on assignments, they need to be well written, focused, analytical rather than descriptive, well structured and logically argued. Wayne talks about using plain English, which is what we've been saying, and I talked about using the active rather than passive voice. What that means is that you try to say something in a positive rather than a negative way. Planning your documents, always prepare a draft. Could I just get that invariably at times you will find yourself with writer's block, unable to make a start. What you need to do in those circumstances is really just get something down on paper. And it's remarkable, once you've got something on paper, maybe if they're just a few words, headings or ideas, it's very, you can start to flesh it out quite easily. So it's really important that at least you make a start. You may discard that material, and that's okay. I should also mention, don't be too precious about your material. What I mean by that is this. You may prepare something, for example, a 3,000 word document, and when you come back to read it the next day, you might think this is just too wordy, it's too convoluted, it doesn't work together, and you've got a choice. You can either try to amend it and rework, move passages around, maybe cut passages out, or alternatively, you simply put it to a side, use it as a reference point, and simply start again. And I do that on a regular basis, and there's nothing wrong with that. So the point is, don't be too precious about what you've written. It can be replaced. And generally, if you've got the skeleton on one side, you can prepare the final product from scratch much more easily than if you were trying to start with nothing, as it were, over to the side. All right, active listening. Now, this is really important, active listening, and I'll just take us back to the screen. Active listening is more than just listening. It's really being aware of the total package of communication. In practice, in law, whether you're in a courtroom or at your office or talking with colleagues, I think listening is an underrated skill, and it's really something that should be adopted very carefully and actively. Now, what do I mean by active listening? It means being proactive in the listening sense. A passive listening situation might be where you're sitting on the couch, half asleep on a Sunday afternoon, watching a pretty dull movie and not really being interested in it. So that's very passive listening. Active listening is, by contrast, in a sense, sitting on the edge of your seat, listening very carefully to every word, watching the body language of the person who's communicating with you very carefully, and being proactive. There are some tips which are very good in the material, which provide you with opportunities to summarise or affirm or just ensure that the person that you're speaking with knows that you are very attentive and interested. And it's a very important part of practice generally. Collaboration skills. Always difficult when you're in a team context. You'll find throughout your university studies that we do try to have you collaborate on a regular basis, and there are some techniques which are very well presented in the material, which give you some ideas on how to go about that collaboration process. Resilience. Now, just generally, that topic is something that you'll need to bear in mind not only through your studies but also in practice. Resilience really means that ability to be professional, to get up every day, to stay with it and keep focused and not lose your cool. There'll be many opportunities for you to lose your way, to lose your path, to just lose the plot when you're in practice. And you've got to try and guard against that and develop some techniques to ensure that you are remaining resilient. Now, can anyone think of some practical ways that we can do that? I know that's a very vague question. Firstly, you've got to look after yourself. What that means is you've got... Hello, Shelley. How are you? What that means is that you've got to look after yourself in a physical sense, and you need to be able to remain on top of things. So you've got to try to avoid being fatigued and keep pushing the diet. But then, now just getting some noise coming through from someone. Now we're not getting so much noise. Okay, not sure if that was you, Shelley, or not, but if you do need to come in, just unmute your mics and come on through. All right, so resilience is really a matter of making sure that you are physically prepared and ready to go each day. But then on a micro level, being resilient means being well organised more than anything else. And I encourage you to get into routines from an early stage because that will guide you through. Be very careful about avoiding clutter on your desktop. Try and keep it clean and try and keep things in the same place. So there are some very practical things that you need to consider when it comes to resilience. We'll talk more about that later. All right. Now, what I propose to do is just refer to the textbook and invite you to have a look at chapter 9 at the start, which is all about communication and collaboration skills. I just want to go through a few things with you. Now, while we're doing that, does anyone have any questions about what we've said so far? All okay? Good.
I have a question.
Yes, Rachel?
One of my questions was in the reading that we did in chapter 9, I think it was. It talked about mediation and it talked about the adversarial system and the interest-based system. And I thought they seemed to clash. And, you know, how would you deal with it if you had a client and you were trying to use an interest-based type of mediation, but the other parties wanted to go adversarial and how that would work? Like, is everything just more adversarial, or is it actually really moving towards interest-based?
No, that's a very good question. Thank you. It's very much moving towards interest-based negotiation. Mediation and alternate dispute resolution is a growing area. It's a very worthwhile tool to keep in mind while you're litigating. And to answer the question, if you have one party that is wanting to negotiate, wanting to look at it from an interest-based perspective, and the other party wants to remain adversarial, the key is to try and get them to the mediation door. Once they're in the mediation process, a qualified and capable mediator has a number of techniques to try to turn that situation around and bring the other party to the table, as it were, and start to negotiate sensibly. So there are a number of techniques in that regard. But certainly ADR is a big area of growth in legal practice. I think I may have mentioned to you I'm a nationally accredited mediator, and we use mediation or conferencing, as it's called, at QCAT extensively. All right, thank you, Rachel. Now, if we could just have a look at the textbook, chapter 9, from page 305 onwards. The first thing is, under 306, there's reference to how do you deal with a number of different issues. For example, the first one, you've been put into a group assignment and it's hard to get people to work together effectively and pull their weight. Has anyone got any practical suggestions? Because it's going to be a real issue for you very soon. Working in a team and someone not pulling their weight. Any suggestions?
I think maybe one thing, John, is if you can approach a person and like you can have a group with all of them together, and if you didn't want to single one out, if you could go over the fact that the work involves all of them and their grades depend on them all having an input and doing well, so they need to support each other. If you didn't want to sort of pick out one person and make them feel uncomfortable, if you could do it that way, and if it didn't change, maybe you could have a word to them on the side, not in front of everyone else, yeah.
Yep, so that's appealing to their logic and pointing out the consequences if it's not done. Thank you. Anyone else? Any suggestions?
Maybe try and talk to them and understand why they're not putting in as much effort.
Yes.
See if there's a reason behind it, or understand.
Thanks, Shelley. There might be some other reasons not even associated with the degree, or they may be losing interest in the degree. So it may be worthwhile to do that, not only for your sake as part of the group, but also for their sake. It may give them an opportunity to discuss something which has been troubling them for some time. Thank you. Any other suggestions? Right, I'll just put forward one, and that is, and it's in the material, but an opportunity for you to come up with a list, a game plan, and essentially some very simple contract between the group members to make it clear that this is your commitment, and to try and come back to that if someone doesn't fulfil their commitment. All right. I just to highlight what I think is a very good introduction, which is at the top of page 307 of your text. I really did like these two sentences. Lawyers are essentially wordsmiths, full stop. They are experts at working with words, both written and spoken form, full stop. Now, the reason I like that is that it's a short sentence at the start in particular. It's a very good paragraph in that it quickly identifies what needs to be said, and it says it in as few words as possible. And that I just wanted to give you that as an example of what we're trying to achieve when you're preparing your materials. Now, there is a risk, of course, with me saying this on a number of occasions, that we might overdo it, and we might have a series of sentences that go, for half a dozen words at a time. I think that there needs to be a flow as well, and quite often the short, sharp introduction is followed by a relatively lengthy sentence, and that's fine. But there should almost be a poetic quality about the way you write, if you can. Just try and make it flow. It will engage the reader and encourage them to read on in a meaningful way. Now, at the bottom of page 308, there's some comments made by the authors in relation to the matter of communication, in particular with clients. It says here that you must understand as thoroughly as possible the legal task that you're being asked to undertake, and it talks about the importance of the initial interview. It is very important in a legal interview situation when you're communicating with the client first up to establish a number of things, and that is essentially your ability, but also your determination to listen very carefully to what they have to say. But be careful about allowing them too much rein. In other words, there are some clients that will simply talk non-stop throughout the half-hour interview, in which case you say, I'm sorry, time's up, and you really haven't done anything other than listen to them. So there must be a time where you are prepared to proactively move in and say to the clients that it is important that they convey to you clearly what it is that they want from you. And one of the questions that you want, one of the questions you might use is, what do you want me to do? Or what do you want? And try to have the client identify exactly what they're after. There is a very good list of things that you should consider doing during that first interview at the bottom of page 309, and as Wayne Jones identified, establishing clearly that the client's material will be dealt with confidentially isn't there, and I think it probably should be there as well. Now, I think it was Rachel, you were asking about mediation and the way it works. There is some reference to mediation and the adversarial approach on page 311. I just want to make some comments about mediation now. All right. Now, firstly, does everyone have a general idea of what mediation is all about?
Yeah.
Okay. So mediation is an opportunity for the parties to come together to work towards making or having a solution to the problem. It's done in conjunction with the mediator, who is there to facilitate the process. Typically, the mediation will occur in a relatively formal setting. It can work over the phone, but it doesn't work as well. It's much better if it's face-to-face. Sometimes it's almost advantageous to travel to attend the mediation. Let me give you an example. We have a protracted, say, family law dispute. It's already cost both parties a substantial amount of money. The lawyers have been arguing their respective cases, but arguing almost down parallel lines. Now, what I mean by that is that the husband has a position where he's arguing X and pushing down that line, whereas the wife is arguing Y, pushing down that line, and the parties really aren't meeting. They're just they're buffering each other, but they're running down towards the litigation, down towards the court case in a parallel line approach. The idea of mediation is that we firstly get the parties together, preferably with their lawyers, in some location rather than telephone. Now, if it gets to the stage where the parties just can't talk to each other, that's okay. The mediator is trained to deal with that sort of issue. And if it really can't be that the parties are in the same room, for example, if there's domestic violence issues, then the mediation can continue in a shuttle situation with one party in one room and another party in the other. We call that a shuttle. The mediator will make an opening statement, and in that opening statement, the mediator will say that the purpose of the mediation is to hand the dispute back to the parties so that the parties have an opportunity to determine for themselves an appropriate resolution. It may not be a resolution which they want, but it might be a resolution with which they're prepared to live. And if both parties walk away from the mediation a little unhappy with the result, then maybe the mediation has been successful in at least that they've resolved the issue. The mediation process will normally start with a statement that everything which is said during the course of the mediation remains confidential. Now, that's very important because in the mediation process, you're trying to encourage the parties to engage, to speak about the issues concerned, and try to resolve the issues. If they have concerns, that if they make a concession or they make an offer, it will then be raised against them in a court proceeding if the mediation is unsuccessful. They're not likely to be very forthcoming or open with their communications. So as a mediator, you need to set the scene to make them feel relaxed and comfortable and ensure that they understand that their communications are confidential. Can't be raised by the other party in the event that the mediation is unsuccessful. It is important for the mediator to attempt to elicit from the parties the main concerns. That's done through an opening statement of both parties typically, and following the opening statement from both parties, the trained mediator will try to create an agenda. Now, the agenda will normally be, if possible, just one word per item, and maybe it could be, say, 4 or 5 items. So once the mediator has heard from the parties, it may be apparent to the mediator that there are issues relating to, let's say, the stepchildren of one of the parties. That's a real issue of concern, and we need to discuss that so that we can move on. There might be issues regarding someone's superannuation policy. There might be some issues regarding allegations of someone gambling, or there might be issues in relation to someone's health, for example. So having identified what the arguments are from both parties, as I said, the parties are running in parallel. The mediator wants to set an agenda where those specific items can be identified, written down, and then worked through. Once the agenda is set, the mediator will then typically have a joint session. What that means is that the parties are encouraged to discuss and negotiate and explain their situation. The mediator is very active with listening. The mediator's light on his or her feet. By that I mean ready to pick up on something that may have been said, something that might be hindering the process of resolving the issue, or something that might be used to encourage the parties to resolve the issue. It might provide an opportunity for the matter to be resolved. So we try and keep in that joint session as long as possible, but if we're not able to resolve the matter, this would have been explained to the parties from the outset, the mediator will then often go into what's called private sessions, which is where the parties there's a discussion between the mediator and the individual parties separately in a private situation. And the rule of confidentiality applies particularly there as well, in that anything which you might discuss with the mediator in that private session is kept confidential and not disclosed to the other party. Certainly not without the specific consent of the party who gave you that information in that private session. Once the private session's completed, typically the mediation will go back into a joint session where hopefully there is a resolution which can then be documented. When you have solicitors who are not well versed in the mediation process attend the mediation, they may embark on an approach which is adversarial. This is my client's case, this is my argument, this is my evidence. A trained mediator will, in a sense, say, that's all very well, but let's not worry about that. Let's not talk about that. Let's talk about ways that we can resolve the issue. What are the points that are common between you? What are the points of differences? Do you understand the consequences of not resolving the issue here at mediation today? Are you prepared for the costs, the anxiety? Mediation provides a great opportunity for the parties to resolve the matters themselves in a way that sometimes a court could never resolve it. Now, for example, we have a commercial dispute between, let's say, a butcher and a commercial customer, a restaurateur. If the matter goes to court, there's only so many options that a court could come up with in terms of resolving that dispute, and typically that would be damages. But in the mediation sense, there are all sorts of other ways that the matter could be resolved. So, for example, it might be, well, look, what if I provide free supplies to the sporting function where you are the sponsor, and I'll do that for you. I don't need any credit, but you're getting the credit and you're making your sponsorship more valuable. So it's just a sort of an interesting way of resolving things in different ways. And you'll see that the negotiation steps are referred to on page 312, where there's a list of 10-step approach, and I've talked about setting the agenda and generating options and trying to solve problems. So what's referred to there is very much along the lines of what's undertaken during the course of a mediation. Now, could I just make some comments about effective advocacy, which is on page 313. Some very good there. When you're in an advocacy, we're normally talking about a court situation, which requires exceptional spoken and written communication skills. But in addition to that, you need research skills, legal reasoning, ability to find factual information, capacity to identify legal issues, argue persuasively, manage ethical dilemmas, and reflective practical skills. In addition to that, there are some practical aspects of courtroom advocacy. Now, I go through these very carefully, but obtain the client's instructions. That would normally be in writing. Identify different ways that you might go about dealing with the problem, or specific advocacy techniques. For example, you might decide that it's useful to bring in a whiteboard and make a presentation, or present some material via CD or DVD. Down the bottom, it says, where appropriate, prepare and seek leave to submit a draft order to the court. I'd add to that, prepare written submissions. It's very powerful, I think, to have something in writing outlining your case when you go to argue something which may not necessarily be decided by the decision maker on the day. If you prepare your submissions logically, where you've identified the issues, you've given some statement in relation to the legal principles, you've given your commentary on how those principles apply to the case, and you've come to a conclusion, all very similar to the way in which you write an assignment, of course, you leave that with the judge or the decision maker when they go away to ponder their written decision or on a reserved judgment. I think you've got a big advantage by having that material in front of them. Now, I just want to give you a couple of examples on what might come up in terms of the work that you do as a first-year solicitor, and why I believe it's important that you take steps to prepare properly. For example, you may be given a task to go to court to make an application to set aside a judgment. Now, a judgment is where the plaintiff, the applicant, if you like, has put forward a claim in relation to something, and the defendant has failed to respond or file a defence. The plaintiff is entitled to seek a judgment by default, meaning that it's an application to the registry to say, I put in this claim or this plaint, there has been no defence filed, I therefore request judgment to be provided to me without having to go through a trial. So we call that a judgment by default. Now, your job might be a person's come into you to say, look, I've just been told that I've suffered a judgment against me. I didn't even know that I had to go to court. I was never served with the paperwork. Or I was served with the paperwork, but it was a family tragedy and I never got round to it, and I didn't file my defence within 28 days. Can you help me? The application would be to set aside the judgment, and in that you would need to argue in front of the court that you did in fact have a good reason for the delay in filing the defence, and you need to convince the court that you have a reasonable defence in the first place. So it's a matter of effective advocacy, going into court armed with the knowledge of what it is that you are required to do to persuade the court to your way of thinking, and then be armed with appropriate documentation to go with it. So it may be that in the material we've got an application affidavit setting out the reasons why the defence wasn't filed, but you might also supplement that with the actual defence and say something to the effect, Your Honour, if you are prepared to order that this judgment be set aside, the defence that we will file is here all ready to go, and that's going to help you. Another example, you might in your first week be called upon to undertake a bail application in the Magistrates Court, and if that is the case, you need to know what the magistrate will consider as important. For example, it might be that the magistrate wants to know where your client will live if given bail, or will your client be studying or working if given bail. Would your client be prepared to consent to conditions such as not consuming alcohol or reporting on a regular basis at the police station? So these are things that the magistrate might want to know, and effective advocacy means that you're prepared for that and you can address those issues from the outset or upon being questioned, and then importantly support that with documentary evidence such as references or letters or certificates. So effective advocacy means more than speaking well. It means being well prepared more than as much as anything else. And when you're preparing, always consider the alternate argument. For a moment, consider what would I be arguing if I was on the other side. Try to anticipate, therefore, what those arguments might be when you're on your feet, as it were, and that'll help you be ready. Also, I think it's important that occasionally you make concessions to the other side. So, for example, in a bail application, you might say something like, it is conceded that my client has failed to appear in the past, and whilst that's acknowledged as being a negative, there are some reasons for it. So you're giving a concession, anticipating a problem, and trying to come in and deal with that problem in anticipation. Right, any questions about what I've said? No one for the moment? Okay. Just moving forward through the text. Okay. I can just take you through to 327, questioning and summarising. There are some suggestions which are made regarding effective questioning, and one of those is ask only one question at a time. Another, I could say, is make sure that your question is based on a fair or established premise. Let's assume, for example, that you're in court, your first trial, you're required to cross-examine and you're required to object when the other party is cross-examining. If you have a situation where, let's say, in a criminal matter, you're acting for a defendant who has no obligation at all to go into the witness box, but nevertheless decides that he or she wants to go into the witness box, they then give their evidence through what's called examination in chief, which is where you as the defence lawyer asks a series of non-leading questions and your client responds to those. That will then be followed by the process of cross-examination, which is where your opponent, the prosecutor, has an opportunity to cross-examine your client in relation to what your client has said. Now, when I say talk about non-leading questions, I mean questions which don't provide an obvious answer through yes or no. So if you're involved in the process of examination in chief, which is where you've got your client in the witness box, you'll be asking open-ended questions. So where were you on the night in question, as opposed to on the night in question, you were at McDonald's, weren't you? You see the difference between the open question and the closed question or the leading question? Anyone got any questions about that? All right. So just coming back to objecting to cross-examination, we talked about asking appropriate questions. Let's say your witness is in the witness box and the prosecution asks questions which are inappropriate. What do you do about it in terms of an objection? One obvious objection might be if the prosecutor wants to ask questions about previous criminal activity, totally unrelated to the matter before the court. You would be entitled to object, and if it's before a jury, probably ask for a mistrial. But that would be something you'd object to. Another one might be if the prosecutor asks a question which is based on a premise which hasn't been established. So if, for example, the prosecutor wanted to determine that your client was driving at 9 p.m. and also that your client was driving a white car at 9 p.m., the prosecutor should not ask a question which is, were you driving a white car? Well, sorry. At the time that you were driving at 9 p.m., you were driving a white car, weren't you? You'd object to that because it's really two questions in one. And the prosecutor should ask, were you driving a white car? Yes, no. Were you driving at 9 o'clock? Yes, no. So just be careful about having two questions really put into the one question, as it were. And that's especially if it's the other side that are purporting to do that. All right. Any questions then about that? Now, I know we're spending a lot of time, but I just wanted to also talk about Chapter 10, self-management skills. There are some considerable, there's a lot of paperwork in terms of depression and mental health for solicitors and barristers and well-being. And as I mentioned at the start, it is important that you plan for that in a positive sense, because you will be under pressure in practicing law, and you do need to be ready to cope with that pressure. There are times, particularly at the start of your careers, where it may seem a bit overwhelming. It might seem as if you're required to be in 3 places at the one time, doing 2 different things in each place at the one time. You just need to be prepared for that. So some practical things are, I'll give you this example. Have you ever been asked by your partner, went out, to bring something home? So, for example, my wife might say to me, when you come home, can you bring some milk? What happens when you come home and you haven't got the milk? It's not very nice, is it? Okay, same thing. Now imagine that if you get down to court and you don't have the affidavit that you wanted to file by leave that day. What do? You're standing in front of the court and you say something to the effect, Your Honour, I have an affidavit which explains that point and I wish to seek leave, and I seek leave of the court to file that now. You then stumble about in paperwork and you think, I haven't got this affidavit. So what do? The key, I think, is that you try to plan for things in a busy schedule. I'm really keen on having a sort of a mindset of doing things straight away if possible. So, for example, don't forget to bring home the milk. I go and put the keys, I put the car keys in the fridge. Now, why do I do that? And there's so many times I've thought, right, I'm going, where are my keys? Where are my keys? Oh, that's right, they're in the fridge. So you can't forget the milk that way. Second thing is, when you're preparing for court and it's busy, I always have my court material in the same place. So when I'm preparing today for court tomorrow, I'll ensure that files are laid out the same way every time, and I place the files in the same spot every time, so that it becomes just a habit that as I'm rushing to leave the court, because invariably I'm going to be 5 minutes late if I don't leave right now, I simply go to the same place every time, and I know that the material is there because that's where I always put it. So having those sorts of techniques might seem silly, but they really do work, particularly when you consider how busy you're going to be and what the ramifications are if you don't have the material at court that you expect to have. So please keep that in mind. Other than that, there are a lot of good strategies on how to deal with stress and resilience and your mental health generally. Keep up your exercise. I try to play golf twice a week and I try to swim 3 or 4 times in session each week. So whatever it is for you, whether it's walking or tennis or Pilates or gym work or whatever, but keep up your exercise, keep up your nutrition, and that will help generally with your outlook, and you'll enjoy your practice of law much more. All right, I'm sorry I've talked a lot tonight, and I hope it hasn't been too much to take in, but I was keen to sort of have our session done closer to an hour rather than going too much longer, because it's too hard to concentrate much longer than that. So, firstly, are there any questions in relation to anything I've said? No? Okay. Well, that being the case, what we might do is I could just go to each of you. Is there anything that you wish to make any comments or any questions generally about the course or the assessments or what we've talked about tonight? Shelley, anything from you?
No.
All right, thank you, Shelley. Rachel, anything?
No, just thanks very much for the information on the sentence lengths and drawing attention to some areas, that help with that.
Okay, that's good. Thank you, Rachel. And Jackie, anything from you?
No, not tonight, John. I'm fine with it all. Thank you.
Okay, that's good. All right, well, I'll stop recording now, and thank you very much for your participation tonight. All the
Thanks, John.
best. Bye.